Hello, landlords. It's Ernie Garcia, landlord attorney, and today I'm going to solve a mystery for you. What is a lease? It's really not that complicated. Let's get started. So a lot of times I have landlords come into the office and tell me, one of the first things they tell me is, there is no lease. Never had a lease, but I want you to evict this tenant that I have. At which point I get a bit confused, because if you have a tenant, then you probably have a lease. So today I want to clear up a few things with regard to what a lease is and what makes a lease. It's really not a lot of parts. And so I'm going to talk about that today. And if you stay till the end, I'm going to point you into the direction of what makes a great lease. So stay to the end for that. But to talk about a lease is basically to talk about an agreement. And people are sometimes mystified by paper and think, well, the only way we have a binding agreement is if we have writing on paper. But that's just not true. Many oral agreements are perfectly enforceable. And when it comes to a lease, your agreement is probably binding, right? So let's talk about what makes an oral lease agreement an actual lease. So first, for any agreement, you have to have what's called offer and acceptance. So somebody is making an offer and someone accepts that offer. That's a contract. That's an agreement. Now, certain states have limits on the kinds of oral contracts that can be made, that certain things require a writing. For example, you cannot sell your house to another person with an oral agreement only. The transfer of real property in the state of Texas and in most states is going to require something in writing. But a lease is not one of those kinds of agreements. You can enter into an oral lease agreement. What makes it up and how do you do it? Very simple. You have to have, as I mentioned before, offer and acceptance. You are offering a place to stay in exchange for something of value to you. It might be money, but it doesn't actually have to be. It could be, for example, that someone is maintaining the grounds. Maybe you have several acres and you're saying you, tenant A, can stay on the property as long as you maintain the property, which includes cutting the grass, or whatever, maintaining the shrubs, watering the vegetation. All these things are non-monetary, but they have value to you. And if in this particular arrangement you agree that someone can remain on the property in exchange for services, you have a lease. The terms of your lease, again, what are you offering and what are you accepting in terms of that offer? That's what creates a binding agreement. And if in this case you're exchanging a place to live for some service, or usually it's money, you have a lease. Remember that a lease in the state of Texas does not have to be in writing. Now, what's created is a month-to-month agreement. If nothing is in writing, essentially the only terms that matter are the address, the place, and then what is being exchanged for value, right? And so if it's 123 Oak Street and the exchange is $1,000 a month, those are the terms. And those terms last for any given 30-day period and continually renew until someone terminates that lease. So in the state of Texas, you can have an oral agreement for a lease, and it is as simple as establishing a place to live in exchange for some value. Now, sometimes parties start off with a written lease agreement, and they'll come into the office and say, aha, I got it. So now there is no lease because the original term started in 1995. Okay, but are the tenants still there? Yes. Same tenants? Yes. You still have a lease. Just because an original term started at some point in the past but has ended That original term has ended, but all the parties remain. The address is the same, the landlord's the same, and the tenant's the same. Nothing else has changed except for that lease term. What you have instead is a continuing lease agreement, continuing on, you probably guessed it, a month-to-month tenancy that can be terminated by either side, but unless terminated, continues forever. That original lease is the last controlling document, and unless it is modified by the parties or terminated by the parties, it survives. So as long as the parties are continuing to exchange the same offer that was originally made in exchange for the same value that was originally accepted, the parties continue with those terms. The only difference is that instead of it ending at a date certain, like a document might say, it ends in the next 30 days, unless it is terminated. So if at any time there was a written agreement between landlord and tenant, that agreement is still in place. Now, can it be modified? Absolutely. From time to time, tenants will change certain terms, but it should have been done in writing. So here's a question I sometimes get in this situation. Well, we had a written agreement. We have since modified the rent. And I'll always ask, okay, can you show me a copy of the written notice of rent increase or any written modification that the party signed increasing the rent? And half the time it doesn't exist. Of course, the other half of the time, the landlords know that the only way you can modify a written agreement is with another agreement signed by all the original parties to the original lease. But occasionally, things like rent and the amount of rent is modified, and you the landlord, never actually sent written notice. Instead, you called up your tenant and say, look, inflation and what have you, rent's going up. And the tenant simply acquiesced and has since paid a higher rent rate. This is why it makes sense to have a good ledger, because you can demonstrate to the court after months and sometimes years that the course of performance between the parties was that the rent was in fact modified. The fact that a written modification is not in place is potentially an issue, a contentious issue that might be argued. And so the easiest way around that is simply to send a written notice. It takes effect at least 30 days after the notice is given. But if you give no fewer than 30 days notice, you can modify the terms of a lease that has since expired and lapsed into a month-to-month tenancy. Without it, there's, again, going to be a fact issue. But if you can prove to the court that the rent was modified and has been modified, and both parties accept that, and that it has been modified for a number of months or years, again, your ability to demonstrate that to the court is essential if, in fact, it's argued against because of what was written. Base rule, if you have something in writing, the only way to modify it is to terminate it in writing or to send at least 30 days notice in writing in order to change a term of that original agreement. The other way is by modification between the parties. And so if landlord and tenant agree to modify something, perhaps you agree to give certain additional amenities in exchange for a higher rent rate. That happens all the time. You can modify your lease, and that addendum or modification agreement, as long as it's signed by all the parties, perfectly valid. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Now, the last instance where we get clients coming in claiming that there is no lease is where a new owner has stepped in. So what's the consequence, or what is the effect of a new owner purchasing property that has a tenant with an active lease? Well, many times new owners are convinced that the tenant and their lease can pound sand and hit the bricks or hit the road or whatever. But that's not true. If you are a new owner and you have purchased property, you take it subject to all of the rights, but all of the limitations as well. And one limitation in this particular case would be if there's an active lease connected to a piece of property, that lease holds. And you, the new owner, would then stand in the shoes, as it were, of the previous owner. And so if there are still 6 months left on the lease, you have to honor that. Again, you could modify it if the tenant agrees to move out. Perhaps you buy them out because you expected to be able to use the property as your primary residence. Totally legal for you to offer a buyout, but the tenant is not required in any way to accept that offer. They are entitled to the remaining months on their lease and can stand firm on the terms of that lease. Now, once it's lapsed into a 30-day, month-to-month tenancy, of course, 30-day notice, you can terminate the lease and then enforce possession. But if you are in the middle of an active lease term, as a new owner, you do not get an automatic termination of the lease. However, there is an instance where that can happen. If you are an owner after a foreclosure, this is different than a purchase. If you've purchased it straight up from a former owner who was a landlord at the time, and the property that you're buying is subject to a lease, you now stand in the shoes of that former owner. If you purchase property at a foreclosure, you are not required in the state of Texas to honor that lease, except to the extent that you have to give at least 30 days notice to a tenant who can demonstrate that they have an active lease and that the lease itself is current. This is going to require that you demonstrate to the court that you have given notice to the tenant of the ownership, that you have made an effort to inquire as to whether or not the tenant has an active lease and they can demonstrate that they are current on that lease, and that you have given adequate notice to them that you do not mean to honor any current lease. Now, could you enter into a new agreement with this tenant? Absolutely you could. There's nothing stopping you from entering into a new agreement. Understand, however, if they present you with the prior agreement, that the terms of that agreement no longer hold. The foreclosure cuts off the terms of that lease agreement, and you, again, can sign a new one, but you're not required to honor it as though it were a binding agreement on you, the new owner, after foreclosure. And it doesn't matter the kind of foreclosure. If it's a tax foreclosure, an HOA foreclosure, or a mortgage foreclosure, you can proceed as you prefer. If you want to give 30 days notice and tell that tenant, I'm not honoring the lease, that's fine. If you want to sign a new lease, that's fine. But you must give adequate notice, and you should be able to demonstrate to the court that you've given those notices and that you've at least attempted to communicate with the tenant to see if a valid lease exists. And then you take it from there as you see fit. If the tenant moves out, you can assume possession. If they remain, then you'll have to go through the eviction process. Now, as I've mentioned, if no written lease term exists and you're looking to acquire possession, naturally you have to send adequate notice of termination. Generally in Texas, that's 30 days. But if there was a lease at one time that required a longer period, make sure you are aware of any longer period in any prior signed lease. You will still be bound by those terms. So that if, for example, a prior lease said you must give 60 days notice in order to terminate, then that's what's required. The 30-day default number of days is only there if the lease itself is oral and never had a written term, or if the lease itself is silent. But if the lease specifically gives a number, it has to be no fewer than 30 days, but it can be more. Make sure you are aware of how many days are required, again, if a prior written lease was signed by landlord and tenant. Thereafter, if a tenant refuses to vacate the property, you can, again, once the adequate amount of time for termination has passed, you can issue a notice to vacate and begin the eviction process with that notice. Now, if you watch my videos in the past, you know that I am no proponent of a 30-day month-to-month tenancy that isn't at least evidence with some kind of writing. You can have a month-to-month tenancy and decide you want your lease to exist that way, but don't do it without something established in writing. If you're coming in and you're a new owner and you were previously bound by the terms of an old lease which has now lapsed, my suggestion is get rid of that lease and sign a new one. Know how to terminate your lease, and then have a good lease in hand to hand to your tenant in order to work from it as you go forward. Naturally, if you have an excellent tenant, you probably want to lock them in for at least a 1-year term. Again, that makes you the most secure. But if you prefer a month-to-month, at least reduce your month-to-month tenancy into a written agreement. Don't simply rely on oral agreements only. An oral lease alone is not going to give you all of the rights that you're going to want, nor is it going to give you something you can adequately point to as a reminder to your tenant of the rights that the both of you agreed to. So always have a written lease. There's a video right here that I've made that previously explains the essential elements of a great lease. If you don't already have one, check this video out. Make sure that you get your hands on a great lease. And if you've got a lease that you don't understand well, this video is going to help you understand it. Until next time, landlords, happy leasing.